impeachment were different. In fact, they were quite non-existent. The rules that exist now is the first time that we see the implementation thereof, and we have to ask, what does that do for the impeachment process? So that's an important conversation we're going to have very shortly. You would recall the judgment from the Constitutional Court shortly after the Nkandla matter, where the Court said that Parliament failed in its duty to hold the executive, in that instance the President, to account. And the argument was that Parliament is structurally incapable of holding the executive to account. Many people argue that's because there is a majority party. It may be different when it's the case that we do not have a majority party in Parliament. It means that the ANC has to vote in one direction. And the argument has always been on the opposition spectrum that if we have a secret ballot vote, that we would be able to convert some ANC members over. And it's right. It happened 2-3 times, actually, when there were secret ballot votes and they were able to convert people over. This time around, they would have to convert. And, of course, leading that charge was Dr. Makosi Khoza when she was still a member of parliament at the time, who was the first to announce that she would vote for the removal of Jacob Zuma. This is the first time we have this debate, and it's not clear what the ANC's parliamentary caucus looks like in its factional alliance to the president, and whether or not there will be a vote, there will be enough people that are being able to be converted by the opposition coalition that's pushing for this. We're going to be speaking to Dr. Fikile Vilakazi, who's a lecturer and political analyst from UKZN very, very shortly. The Competition Commission has raided about 8 or so insurance companies, slightly more it seems. Why is this significant? Why is it important? But importantly, does the Competition Commission, as a Chapter 9 institution and not as an institution that is a law enforcement institution, does it have enough of a statutory empowerment to be able to really hold to account and avert the sort of behavior that that manifest in cartel behavior, right? How do we prevent cartel behavior? And what is the human cost of cartel behavior? If it's true that everything that we suspect about the insurance industry, the prima facie evidence in this instance, if it turns out to all be true, it would mean that the insurance industry of South Africa behaves like a cartel. In fact, it is a cartel. That would be the case. How do we prevent this? And what does true accountability look like in this instance? Typically, there would only be a financial sanction, that is penalties and fines. Should we be able to empower the Competition Commission as well as the Competition Tribunal enough to be able to become an extension of law enforcement in this country? And what would that look like? That conversation is happening. And of course, important judgment coming out of the Equality Court yesterday on the ruling in AfriForum versus the EFF. Interestingly, this judgment is not the first of its kind. And I want us to rewind back all the way to 2010 when AfriForum took to court the ANC and Julius Malema for Dubulibun. That was the song that was controversial at the time. AfriForum won in the High Court, but there was a different order, an interesting mediated order that came out of the Supreme Court of Appeal. How does it relate to the judgment we found this week? And what does that mean for hate speech? What does that mean for freedom of speech? And what's the relationship between the two, especially when it comes to legitimate political speech? And what is legitimate political speech? That's a conversation we'll be having in a short while, in the show as well. Again, give us a call. You can participate in this conversation. Our studio line has changed. The new number is 086 800 2032. Yeah, 086 000 2032. My apologies. My eyesight failed me a little bit. So give us a call on that number. You can WhatsApp us and send us your voice notes on the WhatsApp line 0614 104 107. That number hasn't changed, still the same. Tweet me at Oliver_speaking and stream us live on Facebook, YouTube, as well as Twitter at SAfm Radio. And you can watch the show live. How amazing is that? Let's get the show started.
Here, there, and everywhere. SAfm 104.4 FM in Durban.
And you are listening to This Week Today. My name is Oliver Dickson, and a pleasure and honor to be in your company. Joining me for the first conversation this evening is Dr. Fikile Vilakazi, who's a lecturer and a political analyst at the University of KwaZulu-Natal. Dr. Vilakazi, I want to start here. This is the first time we see a Section 8-9 panel in an impeachment conversation. Of course, the last time around, the impeachment, we've only had but one. The impeachment vote in this country went similar to that of a vote of no confidence, even though in law, it's not the same thing. This panel is an interesting feature of our parliamentary democracy at the moment, because it means that this panel, much like a courtroom, has particular powers. The ability to subpoena the president, the ability to subpoena anybody of interest in this instance, and gather evidence. That's what it's supposed to do. Gather evidence and determine whether or not there may be a case. Following that, we will see a vote, a debate, and then a vote. Very similar to how it's done in the USA, for instance, when we saw the impeachment vote of Donald Trump. What would the implications thereof be in the accountability process?
Good evening to you, Oliver, and good evening to listeners and viewers at home. It's quite an interesting development that we are seeing, that we are going to be having a panel for the first time in the process of impeachment. Quite interesting because you are looking at a situation where we are involving the judiciary. And of course, the role then of the individual, judges that could form part of the panel becomes key, in terms of just their persona, in terms of also their credibility, within the judicial system, their standing. Of course, these are anticipated to be retired judges who probably would be in good standing. So that's the one part, and I'm starting there because there seems to be some level of mistrust on the judiciary, Oliver, in the way that our democracy is unfolding in South Africa. You would see, for example, let's just say Justice Mogoeng's name comes up. Many people are going to begin to say, I wonder if he can be neutral, for instance, as a member of the panel, because he has been seen recently to jump into the ranks of politics, joining a political party. So, and then people, of course, the South African public saying, I wonder if we can trust, judges who can, like any other individual, tend to hold political interests, that can sway them in one direction or the other. So there is that dynamic, but also, secondly, there is also a dynamic around just the rules of procedure of Parliament, because we know previously, Oliver, that we did not have this kind of a panel in South Africa, which meant that the procedure in Parliament was highly reliant on just the voting powers of the members of Parliament. But this panel brings something that is different, in a sense that it really will be able to shape the direction into whether the president can be impeached in this case, or any other person for that matter that is brought into the panel. However, I know you mentioned that it may have certain powers. My worry comes to the report of the panel. How much of the power will the report of the panel hold? How much will it shape the direction of impeachment or not? Also because, the rules that govern the panel itself, in this particular change in the rules of Parliament around impeachment, or Section 89, did not take away the fact that ultimately the decision has got to lie with the voter, who is a member of Parliament. Because the majority rule question comes in here to say, are we going to see something different in terms of the manner in which the African National Congress in particular will vote? So there's that second dynamic. But also thirdly, within the African National Congress itself, Oliver, is the dynamic, since the impeachment call for the former President Jacob Zuma, and now a lot has changed internally within the organization. Yeah. We see within the African National Congress itself, Oliver, that there's a segment and there's a strata that would like to see President Cyril Ramaphosa go. Some of the people have been seen in the public domain calling for the president to go. The question is, Oliver, once the panel has then submitted this report, whatever direction the report suggests, right, and recommends, and let's say it takes us to the direction of impeachment, would that segment of the African National Congress then vote in favor of the impeachment process?
My understanding, and maybe correct me here if I'm imposing a false dichotomy here, but my understanding is that the report of the panel can say one of two things only. Either there are grounds for an impeachment debate where the National Assembly will then take its course, or there are no grounds for that because there's no indication of violation of any laws or criminal behavior on part of the president. Therefore, there can't be an impeachment in vote. Am I understanding the two potential outcomes to be only that?
You are correct. You are correct. That is the mandate, that the panel has been given at this point. It can really tell the public and Parliament whether there are grounds or no grounds. And I mean, let us go back to the Constitution. I think that, be that as it may, we know that just in terms of Section 96 of the Constitution, where a member of the cabinet is not supposed to be holding or receiving any other income, or gainful and meaningful income. For example, we know that in the case of President Cyril Ramaphosa, that ground of the Constitution has been violated, right? So there's that thing. And I think it's going to be very interesting whether the panel will be able to pick up on Section 96.
That's an interesting point. I was debating this with a friend. Is that a violation, Dr. Vilakazi, of the Constitution, or is that a violation of the rules of Parliament, specifically pertaining to the Executive Members' Ethics Code, where the only jurisdictional power there is the Public Protector, and only the Public Protector there can determine whether or not there was a violation of the Executive Members' Ethics Code?
My sense is that it is both. And if you look at Section 96 of the Constitution, subsection 1, it actually says that violation of the Constitution or the law, right? So there's two things here. Yes, the Public Protector is given that leeway, but you are talking about violation of the Constitution and the law in the context of the body of the President, of Honorable Cyril Ramaphosa. You see also the Phala issue. You see the issue of the taxation, possibility of the tax laws also being violated. So it's not just the fact that he is a businessman. It's also because of the Phala scandal that comes with the issue of tax laws in South Africa, which there may be, of course, this issue is sub judice. It may be that he has violated tax laws,
Absolutely.
right? And then there's other underlying issues, Oliver, that come with Phala, which are these claims
kidnapping and the
kidnapping and the violence,
a foreign government,
and so on.
Yeah.
Particularly for the first citizen of the country, those are things that you consider serious. I mean, the Constitution says a serious violation, right? One would have to also, perhaps the panel has got a responsibility to educate the South African public and perhaps to surface what is it meant by serious in terms of the Constitution. And I think that's where the trick is going to be.
086 000 2032. That's the number to dial. Give us a call if you'd like to contribute to this conversation, if you have something that you'd like to ask and add to this conversation. 086 000 2032. That's the number to dial. Dr. Vilakazi, I want to take it here. What makes a vote of no confidence very different textually and materially from an impeachment vote, and why is that difference an important one to notice? I'm asking this because many people can be like, but this Section 89 panel, it just seems like another opportunity for politicians to prevaricate and evade justice and accountability. Why can't we just go directly to the vote? Why then is this an importantly different noted process from an ordinary vote of no confidence?
Look, I mean, any citizen has a right, in terms of the rules of procedure of Parliament. Any member of Parliament, let me put it like that, has got a right to be able to submit a motion, right, in terms of Section 89, to say we are not happy with a particular member, particularly the president, and they need to be impeached. And a vote of no, so that carries a lot of weight in some way. And a vote of no confidence can be expressed, but sometimes it's really not taken serious in that sense. So for me, those are just, I'm putting it simply, like those are the two. Those are the differences between what one would take as a vote of no confidence and an issue of impeachment, which really carries serious violations, either of misconduct, non-performance by a member, but also, just not being able to abide by the Constitution or the law. And vote of no confidence, sometimes it's seen just as a matter of someone just really hating a particular person. It's a question of personality. It doesn't really, most of the time, it's not always taken seriously, which is why the rules were amended in 2018, Oliver. Because there was that with the former President Jacob Zuma, that the members of Parliament, particularly the ANC, did not really take the issue of impeachment seriously, because it was just seen as, this is another vote of no confidence, and before, that's my take on it.
Is the configuration of Parliament sufficient to be able to hold the executive to account in any sense whatsoever? And I'm asking this because it really just seems like it's going to come down to a vote, and the ANC, which has a majority of at least 30 more seats than the opposition collectively, will vote in one direction, and the president will walk away with this not having been impeached, and it will be business as usual. Is Parliament really configured in a way that it can truly hold to account the executive and organs of state?
These are the shortfalls of our liberal democratic system and the majority rule principle. It is failing us, Oliver. It is, I have been saying this in the public domain that I think this is why we are where we are 28 years later in democracy, because the majority principle in Parliament has actually enabled the African National Congress to vote for its members, to toe the line, which is the language that is used by the party, at the expense of citizens. I mean, look at this question that is facing Honorable Senator Ramaphosa. Let's say, for example, the issue of money and pala and tax laws have been evaded. That's a serious crime if it is actually found to be true, in a sense that, Oliver, it speaks to the livelihoods of people. It speaks to issues of eradication of poverty. The tax base is actually what is responsible for making sure that citizens benefit. It is a revenue base of the nation. And if the first citizen of the nation is seen to be violating that, in my view, it's really a serious crime, because I mean, look at South Africa. We've got high levels of unemployment. People are dying because of that. So it's those kinds of things. And I think that the majority rule, the configuration of Parliament in the 28 years that we've been, has not really assisted us to bring the kinds of services that we need to see for the citizens of the country, mainly because the majority rule has voted in the manner that it has. The majority in Parliament, the ANC has done that. So it's not really helping us. And I think in this impeachment is going to be a challenge, Oliver, also because you are seeing that the opposition party, as much as it has risen to say we would like to see the president being impeached, but the Democratic Alliance is not really coming in here to say yes. And they're likely to then vote with the ANC. And the Democratic Alliance is the biggest opposition in Parliament and in South Africa. So where does that take us to? So one of some of the things that we're calling for is to say, perhaps South Africa, it is time that we need to overhaul the system. The political system is faulty. The political system, in the manner that it stands, the rules of procedure in Parliament would need to really be relooked at in terms of ask this question: does actually this liberal democratic arrangement assist us as a nation? Does the majority principle assist us, or do we need to go to a multi-party arrangement that decentralizes power and perhaps getting communities on board as well, who can be able to vote and shape the direction of decisions in Parliament comparatively to what we see? So the configuration, Oliver, to put it just shortly, is failing us. It is faulty, and I think it's actually routine.
And it's interesting that you mentioned some of the alternatives. In the past, what people have argued is that if we're going to say that an impeachment debate and an impeachment vote is so serious that we have to have an entire panel for it and have a process separate with a higher burden of proof from a vote of no confidence, shouldn't this then be put to a referendum? I'm pretty sure the IEC can run a referendum and ask South Africans to vote whether or not President Cyril Ramaphosa should be removed from office. Not whether the ANC should be removed as the governing party, because that is shortcutting democracy, right? But whether or not President Ramaphosa, a deployee of the ANC, should be removed from power, leading it to a situation where Parliament has to vote for a new president, whoever that may be.
Of course, Oliver, that should be a direction that we are taking. We have been saying that a referendum is needed in South Africa on so many levels, for the mistakes that happened at CODESA. Right, number one, to say, why is it that the country did not have a black majority referendum when we had a white-only referendum to determine these kinds of issues? When we are faced with critical issues of this nature as a nation, it's very, very important that we go to the citizens in the country, who are the voters, to say, what do you think? And a referendum is an easy way to actually ascertain that, so that we do not limit decisions, about our livelihoods to members of Parliament who really have demonstrated in the 28 years that they are not capable of deciding in favor of citizens, Oliver, which is why then the question of the referendum is very, very key. It's fundamental, not just on the question of impeachment, but also on the direction of the nation, on the healing project of the nation.
Final
and whether
question.
the system that we have is working for us.
Final question. Coming back to the accountability infrastructure, does the vote of no confidence or the impeachment vote or vote of no confidence under secret ballot, does it make a big difference?
You know, in the past, I would say boldly. Currently, I want to believe that it may assist us in a sense that there are those divisions that you see within the African National Congress, the majority party, per se. So hopefully we can get people really voting on the basis of their oath of office, not because of a particular political party. Remember, when we're talking about the president here, we're not talking about someone that is representing their own political party. We are talking about somebody that is representing citizens of South Africa.
Yeah.
And members of parliament who go to vote secretly are also bound by an oath of office, right? That ethical code that says, I will serve the citizens of the Republic of South Africa. And I want to believe that this time around, perhaps if they go to vote secretly, they may remember that oath and be able to do the right thing, Oliver. It hasn't helped us in the past.
Yeah. Dr. Vilakazi, thank you so much for your time this evening. Really, really do appreciate it.
Thank you so much for inviting me.
That's Dr. Fikile Vilakazi from the University of KwaZulu-Natal who joined us on that conversation. What do you make of it? 011 that's not the number anymore. My apologies. 086 000 2032. 086 000 2032. Give us a call and tell us what you make of that, what is on your mind this evening. On the other side of this, we're going to be speaking about the Competition Commission and its raid of insurance companies. These insurance companies include Bright Rock Life, Discovery, FMI, which is a division of Bidvest Life, Hollard, Momentum, Old Mutual Insure, PPS, which is Professional Provident Society, and Sanlam. It is suspected that there is cartel-like behavior at the center of their pricing, of course through collusion in respect of fees, especially for their high-risk products, such as life insurance, dread disease, disability, life and funeral assistance benefits. We're going to be speaking about that, but the interesting conversation here, I guess we've all gathered through the coverage of the week what the facts of the story are, but the important conversation is, how should it truly be treated? How should we go about configuring our forensics institutions, such as the Competitions Commission, as well alongside our law enforcement institutions? And the question really is, should we change how we approach cartelistic behavior? Should we consider perhaps treating them as criminal cases and not as civil cases? There's an interesting legal development that took place 4 or 5 years ago and it hasn't yet been applied. We're going to be speaking very shortly to Sipho Ngwema, who's the head of communications at the Competition Commission, on the other side of this.
Here, there, and everywhere. SAfm 106.6 FM in Mangaung. Call us on 086 000 2032. SAfm has signed a code of conduct that is enforced by the Broadcasting Complaints Commission of South Africa. Under the code, we are committed to giving news that is accurate, comment that is fair, and programming that is not harmful, does not amount to hate speech, or contain violence or explicit sex. If you think we are not living up to that code, then you can inform the Broadcasting Complaints Commission of South Africa. Direct any complaints in writing to the Broadcasting Complaints Commission of South Africa. PO Box 142365, Craig Hall 2024. Fax to 011-326-3198 or an email to bccsa@nabsa.co.za. For more information, please visit www.bccsa.co.za. For unskippable, no clickbaiting, and cookie-free, with lots of real followers and likes, place your sales campaign on SAfm. Radio is still the best place to advertise your business at affordable rates. SAfm, with its national footprint and top personalities, offer advertisers distinctive opportunities to reach their target audience. Email sales@safm.co.za. SAfm, the influencer you can trust. Oliver Dickson on SAfm.
You would have seen the story on Thursday that the Competition Commission said that on reasonable grounds, they suspect that 8 insurance companies have participated in collusive practices to fix prices and trading conditions in South Africa. What does this mean for you as an insurance consumer? But more importantly, how do we determine the human cost of cartel behavior and collusive behavior? And that is an important question. The head of communications at the Competition Commission, Sipho Ngwema, is with us. Sipho, thank you so much for your time. Has the Competition Commission applied its mind to the question of determining the human cost and human impact of cartelistic and collusive behavior?
Look, that's a very important and difficult question to answer, in the sense that many of these, and I think actually this is why we have a legislation that prohibits cartel behavior, that prohibits companies to collude, because at the end of the day, it is the consumer that is affected, given the fact that prices, when they are fixed, when they are manufactured by these companies, it means that the consumer is the one that bears the brunt of those prices. So the damage is huge to the consumer. And in this particular case, we are told that this matter dates back to the 1980s. So you can imagine many people at the time now who probably have decades of this product were not born at the time. And this then has huge impact in terms of what it does to people, what it does to people's money and pockets, particularly in a country where the consumers are so kind of pressed and squeezed with regards to their pennies.
Yeah. You know, in the public sector, when we speak about, unscrupulous and immoral behavior, the label is corruption. But when we speak about it in the private sector, there's a distinction between collusive behavior on the one end, where the sanction is almost always financial, versus, say, something that would go to the Commercial Crimes Court, something like fraud, which is an actual crime and treated criminally. Should we start treating these things the same way? In fact, what I'm asking you, Sipho, is should we start criminalizing or treating collusive and cartel behavior in a criminal way, where we trial this in a criminal court and not just, where the commission issues or the commission tribunal issues out a fine or issues out a penalty fee, which very often these companies can afford. We've seen in the past, they pay it and they move on. And they remain large monopolistic enterprises in some instances and I'm saying monopolistic or oligarchic because that is the result of collusive and cartelistic behavior, right? Should we start treating these people like criminals? And if so, who exactly should with the sword fall on?
We are engaging our colleagues in the National Prosecuting Authority, because in terms of the Competition Act, this is how the act is defined, or the action is defined, and this is how the breach is defined. And we, as the Competition Commission, can only act with regards to the mandate or give effect to the Competition Act. However, you are correct, 100%. This is fraud. If anything like this is happening, if people sit and defraud consumers at face value, that's common law crime, and it can be prosecuted in a criminal court. And this is why we are engaging with our colleagues in the National Prosecuting Authority, and at the appropriate time, I think we'll reach consensus in terms of some of the things that are happening, because people are defrauded their monies by many actions that these companies are involved in. But for us as a Competition Commission, we can only do what the law tells us to do. Yeah. We don't make the law. We apply it, and we can only apply the law as it prescribes us to do in terms of the Competition Act.
So let's speak about the law. Section 73, 73A, speaks about the criminalizing of collusive behavior. Why have we not seen that being put into practice yet?
As I said to you, we have started engaging with the National Prosecuting Authority, and we're hoping that in the end, we will be able to bring these courts. You must remember also you need some specialization in terms of understanding both acts, but also with the backlog that we have in this country, you can imagine how the courts are. However, I think in principle there is an understanding that very many of these cases must end up in the criminal court. And once we have evidence and once it has gone through the competition tribunal and competition authorities, there is a good motivation that indeed some of these matters, because at face value, they look like fraud, people are defrauded, and therefore they should end there.
Can you explain to us what happens in the competition tribunal? Because my understanding is that it works like a courtroom. It has the powers of the High Court, effectively. Why can't it be tried criminally there?
Because in terms of the law, the competition authorities, to an extent, it's a criminal or it's a civil litigation that takes place, and they're able to find entities with regards to what the Competition Act prescribes, and the Competition Act prescribes in terms of its highest penalty as 10% of the company's turnover. So they do not have those powers, those criminal prosecution powers. That power rests with the National Prosecuting Authority, and this is why we go to the National Prosecuting Authority. And the Prosecution Authority prosecutes in the criminal courts in front of magistrates and judges, and it can only go there via the NPA.
Yeah. Can you sketch out to us what you imagine a criminal procedure or a criminal trial to look like in the instance of collusion? And I'm asking this because my big question here is, who then is going to sit in the dock? Will it be the board of directors of the companies? Will it be the executive management of the companies? In other words, the CFO, the CEO, the head of sales, or whatever the case may be? Or will there be a fall guy down the line somewhere in middle management who they'll blame collectively, and he goes to jail, and they just keep it moving as the higher ups who really got the real dividend of this behavior?
I think in terms of those processes, one has to prove liability with regards to whoever is involved in the value chain, and people must have intentionally known what they were doing when they were doing these acts against consumers, and therefore you should be able to, when you are prosecuting someone, bring credible evidence that the people that you are prosecuting are criminally liable because they were part of the action that had taken place, and you have to prove the elements in terms of proving those people that they knowingly took part in the action and with the intention to defraud consumers. Yeah. And therefore, whoever would have known and would have sanctioned those actions, if the companies are involved, and those people would have to be liable. So the prosecutors, therefore, would have to bring evidence against individuals who would have taken part in those actions. However, the juristic person as a company, I think, also would have to be charged if they are responsible, and therefore you can only get a fine with regards to that. But human beings, they have to be liable if they knowingly took part in the act.
So basically the board of directors could simply say, we didn't know. Ask the CEO, who may or may not be on the board himself.
Indeed, but also it depends on the facts. In some companies we have very active members of the board. Probably some of the things would have been sanctioned at say whatever level. So it will depend on the merits of a particular action and the particular activity. To what extent did board of directors know? But also, I think from a civil part, from a liability part, from a king's governance point of view, there must be some level also of oversight that certain committees and boards must exercise over companies. And I think that those processes as well can prove effective in terms of trying to curb these kinds of actions.
What does Section 73 tell us about what the appropriate sanction would be? How much jail time is prescribed over there? Because I'm assuming it would be a prescribed sentence.
Look, if it's in the criminal domain, I'm not sure exactly, but also it depends on the discretion of the presiding officer. But I suspect on issues of fraud, you can get up to 15 years or more, depending on the severity of the matters. But I think it's a very serious offense, and it should, with regards to sentencing, criminal sentencing, probably people would get up to 15 years thereabout.
Right.
With regards to any matter, they would have been found criminally liable. But also, as I said, there are mitigating factors that can also affect that, and it can anything lesser than that. But depending on their participation, depending on the number of years that this thing has taken place, a number of factors will have to be factored in when people are sentenced.
Yeah. Give us a call, 086 000 2032. 086 000 2032. That's the number to dial if you'd like to add or ask a question or add anything to this conversation. Let us know what is on your mind. Colin in Cape Town, good evening.
Good evening, Oliver. Nice to hear you again.
Thank you so much, Colin. What's on your mind this evening?
Tell me something I would like to ask your guest. The competition tribunals, whatever you call them and whatever they want to call themselves, they go and hunt down companies that actually rob the consumer. Now, a couple of years ago, we had the bread price fixed with various companies. They were fined, I think, something like 40, 50 million. Other companies were fined millions and millions. Now, the consumer has been done in over those years, and the Consumer Council, Competition Tribunal, finds him guilty, fines him 90 million rand. Now, where does that money go to? Why aren't the companies that have defrauded the consumer for months and years sell their bread, for argument's sake, at 4 rand a loaf, and penalize him like that for 4 or 5 years? Insurance companies, funeral policies, and people like that are defrauding the consumer. Where does that money go?
Yeah,
I would like to ask your guest that to answer that.
Brilliant question, Colin. Thank you so much. Really good question.
Compensated.
Yeah, fantastic. Thank you so much for your call, Colin. Really appreciate it. That's a good question, Sipho. This week you guys fined Nedbank 2 million rand for sanctioning a transaction before the Competition Commission could sign off on it relating to a certain M&A. Where does that money go?
In terms of the Competition Act, the money goes back to the fiscals. But also the Competition Tribunal can also issue whatever remedy deems fit in terms of the merits of that particular case. So in some instances, for example, during COVID, where you have a restricted number of people, you can be able to direct companies to refund those people. We're able to do that on a number of companies during COVID time because the number of victims, you could identify them, they were traceable. But also sometimes when it's huge, it's very difficult to be able to trace those victims. So through the fiscus, you can be able then, because the government represents the people, therefore you can be able to say the money goes back to the people.
Yeah.
But in many other instances, there has been instructions or directions from the tribunal for monies to be invested in the communities that were affected by that particular action. So it depends on the merit, it depends on the geographic and location of the offense, but also it depends on the number of years and people that were involved. But most of the time, the remedy is aimed at making sure that the consumer, if possible, is able to be reimbursed. If not, the money goes back to the fiscus. The fiscus, through all its other initiatives, is able to give the money back to the community.
Just a final question from my end. What does collusion look like and how does it happen?
Look, collusion, it's when companies that are meant to compete, companies that are in the same space and sector, selling same things or, offering the same services, they meet together, share sensitive information that should not be shared with respect of competitiveness, the information that then informs their pricing of their products. So that information, for example, if you share with someone you're supposed to be competing with, it means, therefore, there is no competition in that particular space. And when there is no competition in a particular space, the consumer is then disadvantaged.
Yeah.
So in this particular case...
So these guys meet at some dodgy restaurant in Sandton, or maybe a fancy restaurant in Sandton. They say, yeah, hey, for our this is what our risk profile looks like. We're going to be charging people this much for a funeral policy. You guys should maybe look at the same ballpark figure. And really, there's no competition anymore. Am I understanding that correct?
That's correct, Oliver. For example, I come to your space, maybe there's 5 of you. You are selling the cup that you're using now at 6 rand, and I come in at 2 rand, and we write checks. This is now cutting us too fine. We can't go below 2 rand. So you then call me, we sit all together to say, guys, if we are going to compete with this 2 rand, it's not going to make sense, and you are not going to make good margins in 2 rand. Can we all sit down and say at least you're then going to charge the consumer between 4.99 and 5.20? So you have now agreed, wherever the consumer goes, will not pay anything outside 4.99 and 5.20.
Right. Okay. Thank you so much for your time this evening, Sipho Ngwema. Really, really appreciate it. Very insightful, and hope we can speak again as the case progresses.
Thank you. I really appreciate your time. Thank you very much as well.
That is Sipho Ngwema, who is the head of communications at the Competition Commission. On the other side of this, we're going to be speaking to Dr. Dumisani Mabunda, who's a senior lecturer at the College of Law at UNISA, and we're going to be speaking about that court case that came out in the Equality Court, AfriForum versus EFF, on the other side of this.
Hi, my name is Khmotsa Keiji Mweketsi, your host for Seasons, every Saturday and Sunday between 10 and 1.
If I tell you now,
You will hear me playing this.
here we are, still together. You give me something.
And if you love smooth jazz or all kinds of jazzy sounds, you can hear me do this. Seasons, every Saturday and Sunday between 10 and 1.
You strike a woman, you strike a rock.
SAfm celebrates Women's Month under the national theme, Women's Socio-Economic Rights and Empowerment, Building Back Better for Women's Improved Resilience. Every fight gets us closer to the equality and freedom of women. The march to the union buildings was just the beginning. The fight against the oppression of women continues. Women's Month on SAfm.
Here, there, and everywhere. SAfm 104.6 FM in Kimberley.
This week, today on SAfm.
And we now have our final guest for the evening, Dr. Dumisani Mabunda, on the line with us this evening to speak about that case, the EFF versus AfriForum. Dr. Mabunda, good evening and thank you so much for your time. This is not the first time the South African courts have been asked to test an incitement that is born out of an incitement case born out of political speech in song. In 2010, there was the Dubuli Bunu case, and with EFF and with at the time Julius Malema and the ANC. AfriForum again was the applicant over there, and of course there was the Jacob Zuma case with Mshiniwa. Our courts have been asked to test this question time and time again. This is the third time around. Why is this not a resolved issue?
Good evening, Oliver and your listeners. Thank you for the opportunity to try and provide a perspective with regard to yesterday's judgment on the case involving the EFF. Firstly, let me indicate that hate speech means abusive or threatening speech or writing that expresses prejudice against a particular group, especially on the basis of race, religion, or sexual orientation. Now, we want to try and find out why the case that was taken to court by AfriForum was thrown out of court. Firstly, let me indicate that in law, he who alleges must prove. And it appears in this case that witnesses were not able to prove the case based on certain issues, which after reading the judgment I couldn't find. But some of the things may be the exact words that were related to the song in terms of the lyrics. Listeners will recall that when Mr. Malema was testifying, he indicated that he didn't sing the song that was alleged by AfriForum, which means kill the farmer, kill the Boer. He indicated that he said kill the farmer or kill the Boer. And to contextualize the word bull, when it translated in English, bull means a farmer, which means when we go back to the definition of hate speech, which talks about farmers. In South Africa, we have farmers from various backgrounds. It's not only white people. Meaning that if Malema was singing that song, it means he would include killing his own people from his own race. So there are contexts to this. So there are various reasons. As I indicated, that the witnesses that were called may have failed to prove the case beyond reasonable doubt. But what I've read is that Judge Molache left the door open, which I think if you have money, you can appeal. But in this case, I think AfriForum...
Take us there. Take us where he left the door open. What reasonable grounds of appeal would AfriForum have in this instance?
He indicated that there are some areas where if this kind of songs are allowed, may incite people to take the law into their own hands or whatever. But when I look at this situation holistically, you will agree with me. During a rally or meetings of these political parties, there are hundreds and hundreds of songs that are sung. And one is selective to pick this one because it has got one word called Boer or farmer. One will have to look at the other songs as well. If I can take you to my culture...
So can I just pause you there? What then was Judge Mutlatledi's reasoning for why that particular caveat is not applicable in this instance? You say he says, well, in some instances it could be incitement, but here it's not. What's the key difference there?
Yeah, the judgment doesn't indicate what was not presented. But as you know, in court, various issues are weighed in terms of evidence. If one who alleges cannot be able to present this evidence, the judge has no option but to throw the case out of court. So these issues, as I indicate, they are not specific in a judgment. So
AfriForum could not draw the nexus between the singing of the song and certain behavior by certain people emanating from that, objectively so, and saying, yeah, so-and-so went and killed a farmer because Julius Malema sang it.
Yes, correct. I was coming there. There is no single incident that can be linked to the singing of the song in 2020 in Senegal. No single case can be linked to that singing of the song. So, while it may fit in the incitement column, but it doesn't fit in a case that was taken to court. That's why one of the reasons why the judge couldn't link this to the killing of farmers, for example.
So just lastly, Is there a material distinction between incitement and hate speech?
There is definitely a distinction. I gave you a definition of hate speech.
Yeah.
Yeah. Incitement is, I wanted to give you a practical example. In my culture, during the passing out of initiation school, there are a lot of songs that are derogatory or demeaning to people, especially those who are uncircumcised, which can amount to criminal injury because they are directed at individuals. But because it is a situation where it can create excitement, but it doesn't mean that that person who is uncircumcised must be killed or whatever.
Yeah.
It's a similar situation. So
the context also matters.
The context must be understood.
Yeah.
And you will note that we are going to the elections for ANC during December. There will be rallies, and towards the 2024 elections, there are many songs that are sung. Some are directed at the opposition parties, but you will never get a case taken to court because of that song that is directed at that particular party. So I think in this case, AfriForum have to understand one thing. You win some and you lose some. In this case, unfortunately, they lost. And if they want to pursue this matter further, they will have to present evidence. I'm not so sure where they are going to find the evidence, because if the judge couldn't find the Boer killed the farmer in the recording that was presented, where are they going to manufacture another recording that will indicate that Malema said the farmers must be killed? And in that killing of the farmer, I told you that Boer, if you translate it into English, it means farmer.
Yeah, absolutely.
And then, it means that those people who kill people must understand that you're committing a crime, and then you have to go to jail. So,
the burden of proof,
I don't think...
the evidentiary burden of proof is quite high on AfriForum in this instance.
They will battle to prove something, but because they have silences, definitely they may try, but unfortunately they will lose this money.
Absolutely. Dr. Mabunda, unfortunately, we have run out of time, so we're going to have to leave it there. It is 7:07 this evening. Mudupi Makalimela is going to be very mad at me, and my apologies to that. That brings us to the end of the show. I'm back with you next week, standing in on Monday, Tuesday, and Wednesday for Kethi Mutlatlana on The Talking Point. So chat to you then. Tapiso Musiwa has the sports for you on the other side of this. I hope he can give you an actual correct prediction of the Springboks this weekend, this time around. Thank you so much for your time. It's time for your news.
Independent and impartial. This is SAfm News.
Thank you very much, my brother. The top stories this hour: the Gauteng Health